Most people think naming your living trust is only paperwork. Just slap your name on it and move on. But here's the truth. The wrong name on your California trust could cost your family a lot. From their privacy to your home, tens of thousands in court fees. I'm Ali Talai, estate planning and asset protection lawyer who founded Talai Law Offices. And in this video, I'm exposing the hidden dangers of poorly named trust and showing you how to avoid the mistakes that put your legacy at risk. Let's talk about why the name of your trust actually matters. The reality of it is, whatever name you end up picking for your trust, it is not just going to be a label for the trust. This is something that will end up showing up on bank accounts, on brokerage account information, on safe deposit, saving account, checking account, and more importantly, on your real estate. That name will end up showing up in public records. So if the name you have picked is not the right name, or if you have not used it consistently, this will all lead to problems when you're not here. And obviously, when we do these estate planning, when you put a trust together, one of the main reasons that we're doing this is that we're trying to put a plan together so that when we're not around, we could make things easier for our kids. However, if you have got the wrong name in place, or if it hasn't been used consistently, it could cause a lot of problems. All right, so let's talk about what does a typical California trust's name look like. Unfortunately, most of the times what I get to see is the client's first name, last name, revocable living trust. So for example, John and Jane Smith Revocable Living Trust, dated April 25th, 2025. That's where we are. That's usually the name I get to see. I don't really prefer it. If you've seen some of my video, I talk about asset protection and privacy planning a lot. And the reality of it is, if your trust's name indicates your own name on it, and now you transfer your property from your personal name to name of this trust, if we're trying to do some privacy planning, you could see this is definitely not going to get us there, because now your name shows up on the deed again. However, that is definitely one way to take title. It does have some pros and some benefits of having it this way, and then there are some negative and reasons that we may not want to have it that way. But what I want to essentially or initially sort of emphasize on is that date. So whatever trust you end up, whatever name you end up picking for your trust, at the end of it, whatever date you're going to execute this document, that date becomes part of the name of the trust. So again, if it's John and Jane Smith Revocable Living Trust, dated April 25th, 2025, that date becomes part of the name of the trust. So then let's say a few years down the road, you decide to purchase another property. You got to make sure whoever is preparing the deed for this particular property is doing it in such a way that still shows the date the trust was executed. So if you're purchasing a property 3 years down the road, obviously it would not be the same date as the date you sign the trust, but the title of the property will still have to read John and Jane Smith Revocable Living Trust, dated April 25th, 2025. If you put a different date in there, now we have inconsistencies. Unfortunately, we've seen this at our office multiple times, that clients have come in, their children have come in, and parents have passed away, and now we're trying to do trust administration. We had a client recently that they had a bank account with Bank of America, $400,000 in there. And Bank of America, the way they had the account, the way they had the trust, the name of the trust used in the bank account, it was not exactly the same name that we had on the trust. The date didn't match, the format of the name was a little bit off. And believe it or not, they wouldn't give the money to the clients. They wanted us to go to court and get a court order that would rectify this whole problem. So it is essential. I want to make sure that you give this, even though sort of small and minute thing, we want to give it more attention. You've got to make sure that you pick the right name, and you've got to make sure you have it consistently stated in any document that the name of the trust is going to go in. All right, so let's talk about if you should use your personal name in the name of your trust, and what are the pros and what are the cons. pros. Let's talk about that. In California, when you record a property, again, we're talking about real estate. If you have a real estate and now you transfer it from your personal name to the name of your trust, that is considered to be a change in ownership. Wherever your property is, that particular county, when this new deed gets recorded, they're looking to figure out if they could reassess property taxes or not. The law says that the county could reassess property taxes if there is a change in ownership. And obviously, going from your name to the name of your trust, that is a change in ownership. However, there are exemptions and exclusions for this reassessment. A lot of times, if you transfer a property into a revocable living trust, that is an excluded transfer and the property taxes will not be reassessed. However, let's say you named your trust, again, John and Jane Smith, and we're assuming this is your name. If that's the name of the trust and now you transfer your real estate, which was under your, John Jane Smith name, there's a lot less chance that the county will send you some sort of a notification that would say, send us a copy of the trust. So going back, a lot of times when you make these transfer, just like the IRS, how the IRS has the opportunity to audit certain tax returns, the county has the same option. You file the deed, the grant deed or quitclaim deed, making the transfer, the county will review it, and in some cases, they'll send a notice saying, hey, give us a copy of the trust. They want to make sure that, you told them this was a revocable trust, but they want to confirm that this was a revocable living trust. So if the name of the trust you selected states your first name, last name, living trust, the chance of the county sending you a letter saying, hey, send me a copy of your trust will decrease immensely. And in most cases, they may never send a letter and they'll just, be the end of it. So that's could be considered a pro and a benefit of having your trust named under your personal name. The opposite of that is that, well, if you do that, if you have the trust named under your personal name, as we discussed earlier, you don't have any privacy anymore. Your name will appear in the trust. So the other option is maybe you pick a different name, something that doesn't relate to you directly. So maybe, for example, you're going to use Ivy Lux Investment Trust. All right. So that name obviously doesn't have your name in there. If we're thinking about doing some privacy planning, that could be step one. There are definitely other factors that go into proper privacy planning, but that's really number one. So now if you record something like this, the negative could be that the county has a greater likelihood that they're going to send you a letter saying, send us a copy of your revocable living trust. The reality of it is it doesn't really matter. There's not going to be any reassessment because the trust that was prepared was still exempt from any reassessment. It just means you have to do a little bit of work. In our office, we try to help out a lot, and we end up sending a lot of these documents to the county, in most cases before they even ask any questions, just to kind of get it over with. But anyways, we do help out a lot with our clients. That's definitely something that maybe would be considered as a negative aspect of not having your trust name under yourself personally. The other thing is if you have named your trust under your personal name, probably be a little bit easier when it gets to trust administration, when it gets to monitoring the assets of the trust, knowing, whose assets that particular property belongs to, or the assets that are placed in so-and-so trust, we know, or whoever's managing it, they know that it belongs to you since it matches the name of the trust. Your name matches the name of the trust. For those kind of things, it makes it a little bit easier. But again, on the other side, if you're looking to get some privacy, you want to make sure that people just can't find out where your properties are, what the value is and all those things, having different name, a name that does not match your first and last name becomes especially important. The other factor that I want to mention is that when you are coming up with the name of your trust, you don't have to state that the trust is revocable or not revocable. You could have a trust that just says, so-and-so family trust, so-and-so trust. I don't have to say it's a revocable trust. And I would suggest that. Again, going back to asset protection, a lot of times the first thing the opposing side is doing, or, whoever is looking around to see if they think you're a good catch to go after, to bring a lawsuit against you, they'll look at these things. And I don't see a reason why you should just tell the whole world that your trust is revocable. So I 100% suggest that if you are going to put a trust together, you don't mention in the trust document if the trust is revocable or not revocable. And you keep it as whatever name you come up with, preferably something that doesn't relate to your name directly. And then maybe family trust, maybe just trust, security trust. Those kind of names I like much better. All right, so let's talk about naming tips to avoid common mistakes. You got the trust set up, everything is done. You want to stay consistent with the name. Whatever name was used, use the exact same thing. Do not abbreviate anything. Make sure you have the date of the trust in every other document that gets recorded down the road. If you're opening up a bank account, if purchasing a new property, make sure that you use the date for the trust when the trust was created. Even if the trust gets amended or restated, and now it's been, let's say, the year after or 20 years after, again, the date of the trust will always stay the same date when the trust was initially created. One of the other questions that comes up a lot of times when I have clients that I get a chance to speak with and they have done their trust and they have done the trust, but it's a trust that says, John and Jane Smith Revocable Living Trust. And again, we're assuming their name is John and Jane Smith. But the question is, I wish you were around. I wish, I knew that I should name my trust in this sort of fashion, so my personal name wouldn't appear on the name of the trust. And the question is, can I change this thing? How can I update? And the reality of it is, we can make some changes. In most cases, if the only thing we're doing is we're amending the name of the trust or updating the name of the trust, we don't have to redo the entire trust. We could amend the trust. And by amending the trust, we could say, from now on, the name of the trust is this new name. In most cases, what I would suggest to you is that you have the trust updated in such a way that it says the trust is known by whatever the previous name was and by this new name. We give it two names. So that way, first of all, if you do have certain accounts that were named under the previous trust, you don't have to go back and change them. Because if you change the name of the trust and now, the trust says moving forward, so-and-so trust is now recognized, as this new trust name, that's all it says. That means you got to go back and make some changes. And that could just mean more work you have to do. It may mean that you have to spend some money to make those changes and corrections. If you set up the trust that we're just adding an additional name to it and both names are still active, that could eliminate some of those changes. However, let's say you have a property that is under the name of the old trust and you change the name of the trust to a name that doesn't relate to you directly, then at that point, if you do want to make sure the public record is updated, then you'll have to record a new deed, grant deed or quitclaim deed to be able to update that name in the public records. Just one other thing before I end the video, the reality of it is, even if you pick a different name, my suggestion of Ivy Lux Investment Trust, I seem to like that name. But even if you choose a name like that, the reality of it is, it doesn't mean just because the name got changed that nobody could find out, who this property belongs to. Especially if it's real estate, because with real estate, you have this chain of title. So if you had purchased the property in your personal name and then later on we go ahead and change the name, it depends who the opposing side is and what access they have to the documents that have been recorded. So just a quick note before I end the video, the reality of it is some of these privacy planning that I just shared with you as far as how you name your trust, it really just depends when you're going to do this sort of planning. If you're purchasing a brand new property that your name has never been registered on it or recorded on it, and now we put this privacy planning that your name doesn't appear in any of the spots on the deed, that could be a very, very strong privacy planning. If you have already purchased the property and the property's under your name, and then we're changing the name of the trust, transferring the property into this new trust or new LLC, the reality of it is it does still provide you privacy, but it would have been a much better plan if you had done this right from the get-go. We just covered how to name your California Living Trust and how to avoid the common mistakes that most people make. But did you know that your real estate is just a quick search away from a potential lawsuit? Check out this next video where I will show you how to keep your real estate investment private in California.